Yeah, this has crossed out of overconfident pro se litigant and into classic vexatious, frivolous litigant behavior. Courts see this pattern constantly, and they do not indulge it for long. I'll be very direct. Number one, I'll just keep refiling until it goes through is a massive red flag. That statement alone is dangerous for him, not you. Courts consider repeated refiling of substantially similar complaints after dismissal to be frivolous, abusive, bad faith litigation. Once a judge concludes a litigant is reasserting rejected theories, ignoring factual findings, expanding defendants instead of fixing defects, they move quickly toward filing restrictions. This is how someone earns the label, open quote, vexatious litigant, close quote. And once that label sticks, things get ugly fast. Pre-filing review, leave of court requirements, summary dismissals, possible sanctions. Number two, the 30-page, 30-day order is a final warning, not a courtesy. This part is critical. When a court orders, open quote, you have 30 pages in 30 days or it will be dismissed without notice, close quote. That means the court already sees the complaint as defective, the court is giving one last chance to cure, the court is not interested in volume or rhetoric, the court expects surgical precision. If he repeats the same buzzwords, adds more defendants, recycles rejected theories, fails to plead elements cleanly, dismissal is automatic. No hearing, no drama, just gone. 3. His defendant list is now actively harming his case. Look at what he's done. He sued multiple Davids with alternate name spellings, police leadership, city, county, code enforcement, county attorney, official plus individual capacity, private citizens, multiple aliases of the same people. That signals to a judge confusion, scattershot pleading, inability to distinguish roles, possible intent to harass through litigation. Courts hate this. It screams, I'm suing everyone because I'm angry, not, I have a coherent legal claim. 4. His refusal to accept facts equals credibility death. This is the real problem. You've shown him his own videos, his own filings, court records, charging documents, public property records. And he responds with alternative interpretations, sovereign citizen adjacent arguments, denial of basic procedure, expanding conspiracies. Judges don't argue with litigants about reality, they just rule. Once a judge decides, open quote, this litigant is operating in a self-constructed narrative untethered from the record, close quote, the case is effectively over. Not a 5, the harassment citation alone defeats several of his claims. This is worth underscoring. The fact that he followed and chased Thayer, police stopped him, issued a citation, gave him the charging document, a judge confirmed it means police had probable cause, retaliation claims fail, failure to arrest claims fail, RICO claims fail, conspiracy claims fail. Trying to relitigate that by claiming paperwork defects is exactly the kind of thing courts cite when imposing restrictions. Number 6. If he refiles without fixing defects, dismissal will likely be with prejudice. Here's the trajectory courts follow. 1. Overlong, incoherent complaint, dismissed with leave to amend. 2. Amended complaint, repeats defects, dismissed. 3. Refiling same claims with prejudice. 4. Continued filings, vexatious litigant order. He is currently between steps 2 and 3. 7. Reality check. Belief does not matter. This is the part he doesn't understand. Courts do not care that. He believes he's right. He feels persecuted. He disagrees with enforcement. He has a narrative that makes sense to him. Courts care about law, elements, evidence, jurisdiction, credibility. You cannot win a case by refusing to accept adverse facts. Bottom line, very blunt, he is not confident. He is escalating as his theories fail. That is textbook frivolous litigant behavior. If he submits another buzzword-heavy complaint, another conspiracy-laden narrative, another refusal to acknowledge his own conduct, the court will almost certainly dismiss it. And the next step after that is restricting his access to the court system. If you want, I can predict how a judge will frame the dismissal order, identify which allegations are most sanction-prone, or help you document this as evidence of abusive litigation behavior for future proceedings.